Welcome back. This is Chapter 1 in Part 1 of our lecture series. In this chapter, we'll examine international arbitration agreements. The topics that we'll address in this chapter are listed on the current slide. We'll begin with a definition of international arbitration. We'll then consider the contemporary uses of international arbitration and the reasons for international arbitration, the reasons that businesses and states and others use international arbitration to resolve their disputes. We'll then turn to 3 overview sections. We'll first consider an overview of international commercial arbitration. Next, we'll consider international investment arbitration. And finally, we'll consider interstate or state-to-state arbitration. Finally, we'll look to the future, to future directions. Let's begin with a definition of our subject matter, a definition of the subject that we will consider in this series. That subject is international arbitration. We'll begin by examining what arbitration is as distinguished from other types of dispute resolution. We'll then consider that particular type of arbitration, international, as distinguished from domestic arbitration. Finally, we'll consider different types of international arbitration. We'll consider international commercial arbitration, international investment arbitration, and finally, interstate arbitration, the resolution of disputes between sovereign states. Let's begin with arbitration. What is this thing, arbitration? How is it defined? There is no definition of arbitration as a means of dispute resolution in either international treaties or most national arbitration legislation. Neither the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards or national arbitration legislation, such as the UNCITRAL Model Law on International Commercial Arbitration, actually define arbitration. In order to find a definition of arbitration, we must look to the writings of commentators and to the decisions of national courts. 2 representative definitions of arbitration are excerpted on the current slide. In the words of one commentator, arbitration is a contractual method for the relatively private settlement of disputes. Another authority, the Swiss Federal Tribunal, concluded that consistent with the traditional notion of private arbitration, one may define the arbitration clause as an agreement according to which 2 or more determinable parties agree in a binding way to submit one or several existing or future disputes to an arbitral tribunal, to the exclusion of the original competence of state courts and subject to a directly or indirectly determinable legal system. Other authorities have offered different definitions. We can see 2 more on the current slide. Take a moment to consider each of these and to compare these definitions to the ones that we've previously considered. My own view of what arbitration is reflected on the current slide. It draws on the various components identified in the authorities that we've previously considered. Arbitration is, and I'll quote now, a process by which parties consensually submit a dispute to a non-governmental decision maker, selected by or for the parties, to render a binding decision, resolving the dispute in accordance with neutral adjudicatory procedures, affording the parties an opportunity to be heard. Let's consider each one of the various elements in that definition. They're listed on the current slide. Arbitration is a consensual means of dispute resolution, a consensual means of resolving a dispute by a non-governmental decision maker who has been chosen by or for the parties to render a final and binding decision using adjudicatory procedures. Each one of these elements is important. Each one of these elements is essential in order to have this thing called arbitration, which forms the basis for this course, for our webinar series. Let's consider each one of the elements in a little more detail. Let's begin with the requirement that arbitration is consensual. It's a consensual means of resolving a dispute. This requirement, the requirement that arbitration be consensual, not mandatory, not based like the jurisdiction of national courts on the mandatory authority of national or international law, but instead arbitration is a consensual process based upon the agreement of the parties. This aspect of arbitration is reflected in the New York Convention, the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards. Article 2, subparagraph 1 of the Convention, excerpted on the current slide, applies to arbitration agreements, an agreement under which the parties undertake to submit to arbitration. The Convention does not apply to other things. In order for the Convention, the global constitution for international arbitration to apply, one must have an agreement to arbitrate, the consensual resolution of disputes between parties. Likewise, national arbitration legislation makes clear that arbitration is a consensual process. We can see that in the UNCITRAL model law, the model law on international commercial arbitration. It provides, again, paralleling Article 2 of the New York Convention, that an arbitration agreement is an agreement by the parties to submit to arbitration all or certain disputes. And the provisions of the model law are applicable to these agreements, consensual agreements to arbitrate, and to the consequences of those agreements, the arbitral procedures and the arbitral awards, all a consensual process. Other national arbitration legislation is similar. We can see, for example, the Chinese arbitration law in Article 4, again, reflecting the consensual character of arbitration. Based on both the New York Convention and other international arbitration treaties, as well as national arbitration legislation, national courts have emphasized the consensual character of arbitration. They've made clear that the consent of the parties is an essential aspect of arbitration. In one decision, for example, an Australian court concluded that unlike court proceedings, arbitration proceedings are consensual. The South African Constitutional Court reached the same conclusion, holding that arbitration must be consensual. And the German Bundesgerichtshof, the highest German court, held likewise that arbitration is a non-state jurisdiction regarding private law matters based upon the will of the parties. In the view of all these authorities, arbitration is and must be consensual. Absent an agreement between the parties, an agreement to arbitrate, there will not be this creature called arbitration. Arbitration has other essential characteristics as well. The second essential characteristic is that arbitration is a means of resolving a dispute, a means of dispute resolution. This distinguishes arbitration from other types of consensual activities. Arbitration is not concluding or forming a contract. Instead, arbitration is the resolution of disputes that have arisen out of some prior contract or alternatively some prior defined legal relationship. Arbitration is a means to resolve disputes that have arisen between the parties, not a means to do other things. Arbitration is not just a consensual means of dispute resolution by any decision maker. Instead, arbitration requires a particular type of decision maker. Specifically, the decision maker must be a non-governmental decision maker selected by or for the parties. Arbitration is different from national court proceedings, even though both are adjudicatory. Arbitration is not a decision by a standing panel of judges available to resolve all disputes or all disputes between the parties. Rather, arbitration is a process in which a non-governmental decision maker, not a national court judge, not an administrative tribunal of a state, but instead a non-governmental decision maker is chosen by the parties, or if they are unable to do so, on behalf of the parties. This is an essential feature of arbitration, the parties' right to select the persons who will resolve their dispute, non-governmental decision makers chosen by or for the party. We can see this element of the definition of arbitration in both the New York Convention and national arbitration legislation. The New York Convention in Article 5.1d provides that one of the grounds for non-recognition of an arbitral award is that the composition of the arbitral authority was not in accordance with the agreement of the parties. This reflects the fundamental importance of the parties' right to choose the arbitrators. Likewise, national arbitration legislation provides mechanisms giving effect to the parties' right to choose the arbitrators who will resolve their disputes. Articles 10 through 14 of the UNCITRAL Model Law on International Commercial Arbitration are one example of this. And thus, a distinguishing feature of arbitration is the party's right, whenever a particular dispute arises, to select the decision makers who will resolve that dispute for them. Another essential element of arbitration is that the arbitral tribunal, selected by the parties, renders a final and binding decision. That decision finally resolves the parties' dispute. Arbitration is not a means of conciliation or mediation. It is not a process in which the parties seek to negotiate the resolution of their dispute to settle that dispute. Instead, it is a dispute resolution process in which the decision maker makes a final decision that is binding on the parties. One or both of the parties may be dissatisfied with that decision, but the decision is nonetheless final and binding. In that sense, arbitration, like national court proceedings, is again an adjudicatory process, a process that finally resolves the parties' dispute. Indeed, we will see that the New York Convention and national arbitration legislation provide a robust pro-enforcement legal regime for the recognition and enforcement of arbitral awards with minimal scrutiny of the arbitral tribunal's decision-making or decision. That ensures that the arbitral award can be coercively enforced against the award debtor, the party that has lost the arbitration, as well as its assets. Finally, arbitration is a consensual means of dispute resolution, final and binding dispute resolution, that uses neutral adjudicatory procedures. Arbitration, like national court proceedings, is an adversarial process, an adjudicative process in which both parties are afforded an opportunity to present their cases to the decision maker, an opportunity to present factual evidence, expert evidence, and legal argument to a tribunal that will neutrally decide their dispute based upon the parties' submissions in the case, based upon the evidence that they have presented, the evidentiary record, and the arguments that they have made based upon principles of law, their legal submissions. The arbitral tribunal will not independently investigate and decide the parties' dispute without reference to their submissions. Instead, it will base its decision on the parties' submissions after affording them an opportunity to present their respective cases. These elements, which we've just considered, are all essential to the definition of arbitration, a consensual means of dispute resolution by a non-governmental decision maker chosen by or for the parties to render a final and binding decision after affording the parties an opportunity to be heard. That distinguishes arbitration from other types of dispute resolution. What does an arbitration agreement, the parties' agreement to arbitrate, look like in practice? We will consider this question in great detail in subsequent chapters. By way of introduction, an international arbitration agreement looks like one of the model arbitration clauses promulgated by arbitral institutions around the world and excerpted on the current slide. The ICC, International Chamber of Commerce Model Arbitration Clause, reads as follows: all disputes arising out of or in connection with the present contract shall be finally settled under the rules of arbitration of the International Chamber of Commerce by one or more arbitrators appointed in accordance with the said rules. That is an agreement to arbitrate future disputes, disputes which have not yet arisen. It is an agreement to arbitrate, an arbitration agreement that is very similar to countless arbitration agreements included in commercial contracts around the world. The other model arbitration clauses on the current slide are also representative examples of the types of provisions that businesses include in their commercial contracts literally every day. Take a moment to consider the model Untitled arbitration clause, as well as the model Singapore International Arbitration Center arbitration clause. They bear close similarities to the model International Chamber of Commerce clause. All of them reflect a consensual agreement by the parties to resolve their disputes by arbitration in a final and binding manner by arbitrators who they have selected or who have been selected on their behalf through this process called arbitration. Let's turn then to the next element of our definition of international arbitration. Our course concerns international arbitration, arbitration that is international as distinguished from domestic. Our course concerns the arbitration of international disputes, typically between parties located in different jurisdictions or headquartered in different jurisdictions, concerning business transactions that typically cross borders or other types of activities that are international or transnational in conduct. We will see that the international legal framework that addresses this subject matter, international arbitration, is different in many cases from the legal framework that addresses purely domestic arbitration. Arbitration is widely used in many jurisdictions to resolve purely domestic disputes, disputes between nationals of the same country, involving activities occurring entirely within the borders of one country and having no international or cross-border ramifications. Our course does not concern that type of domestic arbitration. Our course concerns international arbitration, the arbitration of transnational or cross-border disputes. Many international arbitration treaties and national arbitration statutes dealing with international arbitration deal only with international as distinguished from domestic arbitration. This is consistent with the purpose of these treaties, the New York Convention most importantly, as well as many national arbitration statutes, which is specifically to regulate and provide a pro-enforcement legal framework for international arbitration as distinguished from domestic arbitration. In many countries, there are different statutory regimes for, on the one hand, international arbitration and, on the other hand, domestic arbitration. We can see this, for example, in the New York Convention, the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, not domestic arbitral awards, foreign arbitral awards. This is reflected as well in Article 1, subparagraph 1 of the New York Convention, which describes the convention's scope, limiting the convention to specified categories of foreign or non-domestic arbitral awards. We can see that in the first and the second sentence of Article 1, subparagraph 1, excerpted on the current slide. Importantly, Article 1, subparagraph 1 does not extend the New York Convention to domestic arbitral awards. It covers only foreign and non-domestic arbitral awards, consistent with the New York Convention's focus on international arbitration. Other international conventions dealing with arbitration are similar. The European Convention on International Commercial Arbitration is a good example. Its title suggests its focus on international arbitration as opposed to domestic arbitration, and Article 1, subparagraph A limits the scope of the application of the convention solely to arbitration agreements concluded for the purpose of settling disputes arising from international trade between physical or legal persons having, when concluding the agreement, their habitual place of residence or their seat in different contracting parties, disputes and arbitration agreements between parties of different nationalities, international arbitration, not domestic arbitration. The UNCITRAL model law on international commercial arbitration is to the same effect. Its very title, the model law on international commercial arbitration, excludes domestic arbitration. The scope of the model law reflected in Article 1, subparagraph 3, is to the same effect. It provides that an arbitration is international if, and then provides a definition of international. Article 1, subparagraph 1 of the model law limits the scope of the model law to international commercial arbitration. Again, focusing, like the title of the model law, on international arbitration, not domestic arbitration. The UNCITRAL model law is representative of other national arbitration statutes. The French Code of Civil Procedure, for example, is limited to arbitration when international trade interests are at stake. And in the United States, the Federal Arbitration Act, the FAA, is limited to circumstances which involve a reasonable relationship to one or more foreign states. Again, international arbitration. Consistent with this, in most jurisdictions, international arbitration is dealt with by a specific statute, a statute often modeled on the UNCITRAL model law on international commercial arbitration. In a few jurisdictions, however, legislation has been enacted that deals simultaneously with both international arbitration on the one hand and domestic arbitration on the other hand. Good examples of jurisdictions adopting this approach are England, Germany, and Hong Kong. Each one of those jurisdictions has adopted some version of the UNCITRAL model law, but has extended the model law beyond what it was originally directed to, international commercial arbitration, to all arbitration, domestic and international. Even in these circumstances, however, legislation of this character frequently has specific provisions dealing only with international arbitration and other provisions dealing with domestic arbitration. We can see examples of this type of legislation on the current slide. Examples drawn from the English Arbitration Act of 1996, the German enactment adopting the UNCITRAL model law, and the Hong Kong Arbitration Ordinance, each one extending to both domestic and international arbitration. These approaches are unusual, though. They are outliers. In most jurisdictions, international arbitration is the subject of specific statutory regime tailored precisely to international arbitration and not dealing with domestic arbitration where different legislative policies and interests may be at work. Our subject matter then is international arbitration. International arbitration can take several forms, however. International commercial arbitration, which will be the principal focus of this course, is directed towards the use of international arbitration to resolve disputes typically between businesses arising out of business or commercial contracts, profit-making enterprise. In contrast, international arbitration can also be used to resolve investment disputes, a particular type of international dispute. As we'll consider in subsequent chapters, international investment arbitration involves disputes between foreign investors and host states. A distinguishing characteristic of investment arbitration is that it will always involve a sovereign state as one of the parties, and that typically the opposing party in an investment arbitration and international investment arbitration will be an investor from a different jurisdiction who has made a foreign direct investment, a cross-border investment in the host state. Finally, international arbitration is also used to resolve interstate disputes, disputes between sovereign states typically arising under public international law. All three of these types of arbitration are international arbitration: international commercial arbitration, investment arbitration, and state-to-state arbitration. None of these are domestic arbitration, and none are dealt with by domestic arbitration legislation in different states.